Look at it and tell me if it's a good deal. Sure, happy to take a look at it for you. So after the workshop, she shows it to me, and it was, go back to the prior slide. Where'd it go? No? Go back one more. It was one of those. I said, that's not a loan modification. Well, they told me that's what they were sending. And I said, well, they were either mistaken or they lied. Yeah, banks are a little tricky. Okay, next slide. Now, remember I said the general rule is you're obligated to pay the remaining balance on those loans unless you can find an exception that may apply to you. Well, there's two notable exceptions that we frequently look for. One is under 580D of the Code of Civil Procedure, and we spoke about that briefly. That's when you have a non-judicial foreclosure. And then we have another one called 580B, B as in boy, under the Code of Civil Procedure, and we call that's the purchase money protection. 580B, B as in boy, of the Code of Civil Procedure essentially says this. It says, when the proceeds of the loan are used to purchase a single-family residence of 4 units or less that is owner-occupied, then the borrower shall have no obligation to pay on that loan. That's kind of important to know, right? That's kind of valuable information. If the proceeds of the loan are used to purchase a single-family residence of 4 units or less that is owner-occupied, then you might have 580B protection. The bank's sole recourse then would be to the property as to that loan, and only as to that loan. That's important to know. Well, what happens if I refinance? What happens if I refinance? Ooh, that gets to be tricky. It depends. Is it with the same lender? What if it's a different lender? What if you, at the date that you purchase your property, you have one loan, and that loan is with Wells Fargo? Well, that's a purchase money loan, because you moved into the property. The proceeds of the loan were used to buy it. Wells Fargo has a purchase money loan. Their sole recourse is to the property. They can't sue you. But what if you run out to Bank of America and say, Bank of America, I want to refinance this, and you refinance it with Bank of America? What were the proceeds of the Bank of America loan used for? Were they used to purchase the property? No, they're used to pay a pre-existing debt. So it's not the Bank of America loan. The new loan is non-purchase money. No 580B protection. So that you no longer have that one exception to the rule. And you're going, I wish I would have known that at the time that I did the refinance. What if your purchase money loan is with Wells Fargo, and you go back to Wells Fargo, and you refinance with Wells Fargo? Ah, that's a different story. There's case law out there that suggests that it remains purchase money. The purchase money status follows the new loan because the parties are the same, the dollar amounts are the same, the property is the same. So it's still purchase money. The courts have demonstrated that they disfavor banks and lenders trying to circumvent California's anti-deficiency statutes. And that's a blatant attempt to circumvent California's anti-deficiency statute, 580B. If they could just simply refinance or rewrite their own loan where the dollar amount and everything else stays essentially the same, that would allow the banks to easily get around 580B protection. What if you refinance with Wells Fargo and you start pulling money out? of the loan. Say, I don't want that Cadillac Escalade. I've always wanted a Cadillac Escalade. I'm going to go get me a Cadillac Escalade. So you refinance and you pull $60,000 out of the property to buy yourself that Cadillac Escalade. Did you just blow your purchase money protection? You may have. It's unclear, but you may have. It's a question of fact that will ultimately be decided in a courtroom. But you may have. You may have. So now, are you starting to get the picture now how all of this comes together differently from household to household? People behave differently. People behave differently. Okay, next slide. Look at that. I put that together this morning. I don't take any pride in my graph, my computer skills, but I put that together. What I want you to understand, because we're ultimately going to start talking about short sales here in a little bit, but before I do, it's important for you to understand 580D protection, what 580D protection is under the Code of Civil Procedure. And here's what it essentially says. It essentially says this. When the trustee, under a deed of trust, exercises his power of sale, then as to that corresponding loan, the borrower shall have no obligation to pay. What the heck does that mean? What the heck does that mean? Well, that's a non-judicial foreclosure. The trustee exercises his power of sale in a non-judicial foreclosure. And remember what I said before, non-judicial foreclosure, probably not going to have to pay on that corresponding loan. Okay? This is a graphic where you use that square. It's supposed to represent that contract called a deed of trust. Okay, California doesn't use mortgages. We use something called deeds of trust. And just like a testamentary document, a trust, there are three parties. There is somebody called a trustor, a trustee, and a beneficiary. The trustor, it ends with the letter R, so therefore it's the borrower. Ends with an R, borrower. Trustor, borrower. The borrower is the trustor. He's the one that places the house inside of the trust, the deed of trust. The beneficiary of the deed of trust is the bank. It starts with the letter B, therefore it's the bank. That's how I remember it. That are the ones that get the benefit of the trust. The trustee, just like a trustee in a testamentary document, has certain powers or responsibilities. But in a deed of trust, they're left with two. The trustee only has two powers during the period of time that the house is in the deed of trust. The two powers are the power of sale and the power of reconveyance. Those two powers arise under one of two circumstances. The first circumstance is you pay off the loan. If you pay off the loan, the trustee is going to exercise his power of reconveyance, and he's going to give you clear title. He's going to remove his lien to the property. That's the power of reconveyance. That happens, again, when you pay off the loan. The other event that triggers the other power is when you don't pay off the loan. When you don't pay. You stop making payments. Then the trustee has the power of sale. He has the power to sell the property and take the sales proceeds and distribute them to the beneficiary, the bank. You with me on that? So 580D says when the trustee, under the deed of trust, exercises his power of sale, then as to the deficiency balance, the trustor has no obligation to pay the bank, the beneficiary. Now, if you sell the property as a solution to your mortgage distress, who's selling the property? You sell the property. You go to a real estate agent. Whenever you hire a real estate agent to sell the property, who is selling the property? The homeowner. selling the property? When you hire a real estate agent, is it the trustee under the deed of trust exercising his power of sale?
Yes.
Is it? No, it's you.
Oh.
You're the one selling the property. You, the homeowner. Not the trustee.